Sean Diddy Combs is at trial, and day one started off with jury selection. Let's take a look at what happened inside the courtroom today. So far, some potential jurors have been dismissed as the judge, defense attorneys, and prosecutors are whittling down a pool to 12 jurors and 6 alternates. Attorney Eric Fudali, who represents women accusing Diddy in civil court, told NewsNation that he expects jury selection to last through the end of the week.
It's a very slow process. It's a very deliberate process. In a lot of criminal and civil cases, which are the cases I do, this jury selection is one of the most important aspects of the case.
Joining me now is Nima Rahmani, who is a former federal prosecutor. Thank you so much for making time today, Nima. Really appreciate it.
Of course, Sophia. Thanks for having me as always.
So first off, can you just break down the jury selection process? What exactly happens so that we can understand what happened in that courtroom today?
Sophia, it's called jury selection, but it really should be called jury deselection because this is what happens. The judge will bring jurors into the courtroom, and Judge Subramanian is actually doing this individually. So the first wave is 150 potential jurors. He starts by asking the questions: what they do, have they heard about the case, have they been a victim of sexual assault, do they know anyone who has? And if the judge determines that they can't be fair and impartial, the judge will remove that potential juror. Then the lawyers from each side get to ask their own questions. And what they'll try to do, if they don't like the juror, is to convince the judge that that potential juror can't be fair and impartial. That would be a challenge for cause, and the parties get unlimited challenges for cause. If the judge agrees, then that juror is removed. If that juror can be fair and impartial, then the parties can use one of their peremptory strikes, and those are strikes that can be used for any reason or no reason at all, as long as it's not a constitutionally prohibited reason, like race, sex, national origin, religion. So the jurors that remain, the last 12, those are the jurors on the panel, the jurors that haven't been struck by the judge or any of the parties. And of course, in a case like this, that's going to go on for weeks, the judge will want some alternates, somewhere I would say between 3 and 6 alternates in a case like this.
Yeah, it's going to be 6 alternates for this one. So this is I can imagine how difficult it is to sit a jury for a high profile trial like this. What do you think defense attorneys are looking for? What do you think prosecutors are looking for? Like this last pool, what are both sides going to want?
Everyone says they're looking for a fair and impartial jury, but the only person that's really looking for that is the judge in the case. Of course, the parties want jurors who are favorable to their case. So if you're the prosecution, you want to remove anyone that's a Diddy fan, maybe a stealth juror that wants to get on this panel, write a book about it. You want someone that's going to go along and not really rock the boat, because you want 12 out of 12. Even 1 or 2 jurors can hang your panel. So you want to avoid those types of strong-minded jurors. From the defense's perspective, of course, they want jurors that are going to be more skeptical of the Me Too movement. Some of these victims waited years, even decades, to bring these allegations forward. They filed civil lawsuits. So the defense theory, of course, is that this was all consensual and the victims are fabricating the stories because of money, fame, or revenge. So jurors that may go along with that defense theory, those are jurors that the defense is going to want. And the irony is, in many sexual assault cases, the worst jurors for the prosecution sometimes are female jurors, especially conservative female jurors, because they may ask themselves, well, I would never put myself in that situation where I am with, an artist or a man in a hotel room. So this necessarily isn't rape. This is regret. I don't agree with that as a former federal prosecutor and someone who's prosecuted sexual assault cases, but those can be difficult jurors for the prosecution.
In that case, would that be something that would be for cause, or that would have to be without cause, a peremptory challenge that you were talking about?
What you want, if you are the prosecution, is to get those types of jurors to say that they can't be fair and impartial, to get them on the record saying, you know what, I personally would never go up to a hotel room, whether it's a Harvey Weinstein or Sean Diddy Combs. When you have jurors that say that and sort of already have prejudged the evidence and what these victims may testify to, then the judge in the case may remove them for cause. Because we, of course, know that going to a hotel room is not a license to be raped, is not consent to be sexual assaulted. But there are some potential jurors that may blame the victim and say, you know what, they put themselves in that situation.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.